Hello, everyone. Happy Sunday. I hope you're having a great weekend. We got a little bit of it left. So thanks for coming to share yours with me a little bit. So today, we're talking about some of the latest filings. And I was looking at it and thinking about it. And Blake's claims, what started off as a work harassment claim, has changed so much. A lot of us have mentioned it for quite a while now that it seems more like she's more upset about people talking bad about her than anything. To the point that a lot of us have started to question what's the real purpose of this whole lawsuit. Excuse me, I have to sneeze. Sorry, guys. Anyway, this late summer is my allergy time. So a lot of people have it in the spring, but mine comes in August and early September. So it is not fun. But let's start off, and I'm going to try to save comments for the end so that I can get through everything more smoothly. I get easily distracted, I lose my place, and then it sounds really messy, especially for people who aren't watching it live but are coming back later to watch, and they're not taking part in a conversation, so it seems really disconnected. So please don't feel bad if I ignore comments for now, but I will save time at the end so that we can all have a little chat about everything. So I'm kind of going to read through the script first and then we'll discuss. I might stop throughout a little bit just to have some little conversations. But for the most part, I want to stick to my script and then save comments for the end. So don't feel ignored. I'm very, very happy that you're all here. Let's start off by saying we're at the point now of not even pretending that this is about SH. This is absolutely and completely about Blake not being able to handle criticism. I'm not a doctor, but it's known and discussed that there are certain personality disorders that just are not wired to be able to handle criticism. The reaction that comes from the slightest hint of criticism is off the charts for some people. It leads to the kind of behavior that most of us cannot fathom doing ourselves. I feel like we might be experiencing this in real time. We've seen leaks now of people who are saying that they were approached right before the lawsuit by Blake's team, telling them that something big was coming and that they should take down their critical posts about Blake. These posts were put up for her tone-deaf marketing of the movie, or from other interviews and things that she'd done that rubbed people the wrong way. But they were told to take those down, that something big was coming. We've also seen leaks of what it was like to work in Blake's company, how those people were all muzzled with NDAs. They couldn't talk about the situation. We've seen threats sent to journalists who criticized her tone-deaf marketing or her glorifying the time period that most of us as Americans are ashamed of: the era of using enslaved people to grow wealth. Things normal people apologize for and try to do better in the future, Blake has historically taken these other routes of not apologizing, not admitting fault, and waging war with anyone who dares to say that she's wrong. This stuff is documented. It's not idle gossip. It's not made up. It's not pretend. That's what actually brought us to this lawsuit. In the opinion of many of us pro-truthers, as I don't call myself pro-Baldoni, I call myself pro-truth, And that means I've already adjusted my opinion one time. I'm capable of doing it again if that's where the truth leads. And I think that's where a lot of us stand. But Blake wanted this movie. Her husband tried to buy it, but it didn't work. She used every tool in her bag to force it out of Justin's hands. After getting her way to take over every aspect of this movie and get her PGA credit, all that was left was the fear that Justin and the crew may expose what she'd done. There had to be a way to ensure that that wouldn't happen, a way to keep him and everyone else quiet. She thought she had it all covered, but what she didn't expect was that anyone would fight back. Even more, that we wouldn't believe her. Now, with her accusations being questioned in a court of law, what started off as an accusation that Justin had retaliated by smearing her in some mystical, magical, invisible smear campaign, it began to dissolve under the scrutiny of discerning people who are not starstruck by celebrities, but who live for truth and justice. With each new filing on the docket, it became increasingly obvious that there was no smear campaign, but that people like us everywhere had actual brains. That we didn't just take her word for what happened, but we wanted actual proof. The blame shifted from Justin to his PR people, Jennifer Abel and Melissa Nathan, thanks to Stephanie Jones providing certain documentation to Blake. Then Justin showed proof that the text that Blake had provided to the New York Times, who, having lost all integrity in my opinion, had excitedly posted the fragmented, cherry-picked texts to tell a false story. We heard the awful way that Jennifer's phone was taken and her privacy violated. Possibly in a criminal way, as we saw criminal causes of action were added to the docket. The focus had to shift. We moved on to Jed, who was quickly doxxed and his medical privacy invaded when he filed a suit against Blake first. But that's okay. The next list was already in the works. 107 content creators, including myself, were served using a Costco bulk buy one, get 106 free subpoena. It looked like Ezra had time traveled to print it on a Mimeo machine that I'm told by one of my describers smelled like spoiled milk. But onward it went, magically being able to serve not only 107 separate individuals, but on multiple platforms, served at varying times with different due dates, and even asking for different pieces of information. This is not allowed with subpoenas. The public only knows so far about 43 of these, so thoughts and prayers to the mysterious 64 unknown victims, whose information may have already been grabbed. In a surprising turn of events, the content creators fought back. Viciously, some might say. Motions to quash were filed along with strongly worded letters that the media started to pick up. Brave Josh Boswell of the Daily Mail started it off, and eventually our darling Lauren Knighty broke through not the fourth wall like Ryan Reynolds, but she broke through the seemingly impermeable wall into mainstream media when she wrote an amazing letter asking for a protective order and sanctions. Our brave heroine was the player Blake and Ryan never saw coming. Now, news that's only been available on social media has spilled into the mainstream. While Blake and Ryan used good old People magazine to try to win back the narrative by painting Justin as an abuser for appearing at the deposition, as we all know is his legal right, People is getting bombarded with tweets and comments calling them out for not telling the whole story and painting it in a bad light. The powers are indeed shifting. At the same time, breakout hero Kevin Fritz has added a new power to his voice and is demanding the court recognize the insanity of Blake's accusations and endless requests that the court bend the rules for her. The content creators and Kevin have put forth to the court the ways that Blake's attorneys have been lying in a way that can no longer be covered up. What's a girl to do? Change the narrative again. Instead of an invisible smear campaign cooked up by Justin, and then Jen and Melissa and Jed and the content creators, now it's Justin's attorney, Brian Friedman, who's the bad guy. After all, didn't he call her a beep? Well, no, he didn't. But that didn't stop Michael Gottlieb from telling Judge Lyman in the hearing that he did. Let's have a look in today's episode, The Sisterhood of the Traveling Blame, when you're almost completely pretty sure there's a smear campaign. So we find this letter that was filed on August 1st from the very angry, eternally angry Michael Gottlieb. Let's point out, first of all, well, possibly because I've just seen a different journalist's take on the hearing, and it was from Don't F with Justice. She tagged me on X, and I thank you for that, by the way. So there was another journalist that was there that was also taking notes on what was said at the hearing. So there were some more captions that they caught that we hadn't seen before. So in there, Judge Lyman did mention that Brian Friedman's subpoena, he called it tremendously broad. And he said it's actually quite chilling. So maybe those comments might have scared Blake's team for the first time. Because this letter, it's not normal protocol to follow up a hearing with a letter. To me, this looks like a sign of worry. That maybe after this hearing, and remember, the hearing was about a motion to quash the subpoena that was served on Friedman's law firm. So maybe for the first time after a hearing, they got afraid that the judge might not rule in Blake's favor. And so, in his nervousness, he hurried up and typed this letter and got it filed really quick. And hey, from his point of view, he gets to hit Blake up for another $500 to $2,000 to do it. I mean, if this case is going to ruin these attorneys' reputations, they better milk it for all the Mint Mobile cash that they can, while they can. So he's still yelping about these interrogatories. We thought this had already been cleared up when the list got shown. And they keep saying, we can't give you something that doesn't exist, but it doesn't really stop them from asking. We see also in this filing that these illustrious law firms have finally learned the art of redacting. So let's give them a little hand for that. They've learned how to redact, or at least for Blake. So they say, hey, you didn't produce the content creators lists. But like I said, I thought that they had already provided those. I thought we'd already seen all that. So maybe they're asking for something different here. But they say here at the bottom, the Wayfarer defendants do not appear to have produced or included on their privilege log any communications by their counsel, as it does not appear that their responses to the interrogatories identify content creators or reporters or media outlets with whom their counsel have communicated. So maybe that list was just exclusively talking about TAG and wasn't the attorneys who normally don't have to provide these kinds of things. But it continues on, repeating what was said at the hearing, that they're saying these are not privileged work product. Because why? Because he says so. He accuses the latest target, Brian, as acting as a publicist and not as an attorney, which is kind of a rude thing to say. And we're going to get into these accusations. He says at the bottom, communications from non-parties to counsel for parties in a lawsuit generally do not qualify as attorney work product. So they are really zeroing in hard on Brian Friedman, which is a very strange thing to do in a lawsuit. But he moves on to say that notice was given back on December 23rd, 2024, that Brian had defamed Blake and acted as PR and not as an attorney. And again, he states this because he says so. He doesn't back it up with, oh wait, he does. Sorry, there is a filing, document 17. It's an exhibit. So he says we told him to preserve documents for discovery and that he was a fact witness, which is kind of a stretch. And any comments he made about Blake would be subject to discovery. Again, because he says so. These aren't things that the court ruled were true. These are things that he took a stab at. So if we think about this date, December 23rd, this is before the actual lawsuit had happened. This is a couple of days after she filed the CRD complaint, which she filed on December 20th. And then the New York Times article came out the 21st, but the lawsuit wasn't filed until December 31st. Yeah, trust me, bro. I see Gigi said that. So they included as their evidence their exhibit, and it was the interview that Brian Friedman did with Megyn Kelly. You've probably already watched that. I had put a link to it back when it first aired. But in there, he includes this, and it's kind of silly of him to do so because he said in the hearing that Brian had called her this word. And then he attaches evidence to say that that's not, in fact, what happened. And he doesn't narrow it down. He puts the entire transcript here. So I'm sure the judge is just absolutely thrilled to read all of these pages, and we're not even going to read them all. We're going to focus on a couple of things, but this was right after Judge Lyman dismissed Justin's portion of the case. So Blake's team were running their mouths. They were doing this victory lap, making it like they'd won the whole case. The people who had written all of those amicus briefs, they were also doing a victory lap, telling the world that his case was dismissed because of their briefs. And people were squawking about my least favorite topic, 47.1. But this is all ridiculous because the judge himself said that he'd never read any of the amicus briefs. He put it right there in his order. He also said that he didn't touch 47.1. So any of the squawking that happened at this time was completely baseless. But if we look at this interview, we see Megyn starts and she asks what he makes of the victory lap that Blake and her attorneys were taking, claiming that it was vindication, which was a really big exaggeration of what had actually happened. They called those counterclaims a sham. They said the judge saw right through them. And there was all these thank yous. And I had forgotten just how many organizations were involved in those briefs. It was 19. I do remember they were clogging the docket up, just brief after brief. And The attorneys had even paid money to be added pro hoc vice. It was very, very silly. But he answers and he starts off, you can tell he's trying to be careful. He says, without getting into detail on that. And then he tries to stick to just basic facts. The judge made clear that he didn't read the briefs. He made clear that he didn't rule on 47.1 and that that's what they were celebrating on. These are all facts. So that's what you have to look for in this whole conversation because that's what's important. He goes on to say you've got to ask yourself who's the real victim. The real victim is just Justin and the others. And it's because they've been wrongly accused. And ask yourself, when you've been in a situation where you've been wrongfully accused, how do you defend yourself? Are you allowed to defend yourself? Are you allowed to lead with truth? Because that's all that's been done here. That's a very important statement. So keep his statements in mind. We're going to get to the legalities of this a little bit later. So he talks about what he did at the beginning that received a lot of criticism, that he put everything out on a website. He put it out there for the public. He didn't hide anything. And he said, here it is. Was there sexual harassment? Was there a smear campaign? So if you remember, it was the entire timeline, and that timeline came from what was Justin's amended complaint. So nothing was there that wasn't a part of court proceedings. He also put the entire cut of the dance montage because she had made those accusations. Now, at this time, people criticized him. People thought he was making a mistake. But this was a man's life. And I don't know if you remember where things stood at that moment in time. Right now, Justin has a lot of people supporting his side. And I don't want to say just Justin. I want to say the Wayfair parties. I always try to correct myself because he's not the only victim. And he's certainly not the only person who is accused of inappropriate behavior. And not the only person that was affected. But at that time, these people's reputations were at stake. They were getting death threats. Justin actually took his whole family and escaped. He was probably the only one that was in a position to be able to do that. But I'll bet every last one of them wished that they could have done that as well. Because as we know, there were death threats, there was arson, there were threats made against Steve's wife and young daughter. He was blackmailed with or extorted, I can't even think of the right word for it. But his daughter and wife were threatened, asking for money after, of course, they were doxxed. But it was a scary time. And to be accused of something so sickening, especially as a married man, he had his wife, he had his children, he had his parents. He wanted this, and you can imagine, he wanted this cleared up, and he wanted it cleared up fast, not waiting for however long this trial was going to take, and to see what kind of evidence might get leaked to an untelevised trial. So he chose to let this one video, where the majority of her claims had come from, to be put out there. And I can't criticize that. I would want to do that. I would want to do that for someone that I loved who had been falsely accused. And it was at that moment that a lot of us here today realized something was wrong with the story. So it was definitely, in my opinion, the right thing to do. So some other things he said, we're not even going to read all of the highlighted portions, but he mentions that it's not dangerous if you know you're right. He says the case has always been about facts. It hasn't been about victory laps. It hasn't been about Saturday Night Live tours. It hasn't been about the People 100. He meant the Time 100. It hasn't been about the show. It hasn't been about misrepresentations. It's been about the facts. He's being very careful about what he says. Keep these words in mind, like I said before. So he asks about Have we seen text messages? Have we seen evidence? Have we seen receipts? No. You've only seen them from one side, and it's been out there because at that point, we had all of Justin's stuff. We didn't really have good evidence from Blake. We still don't. What we've seen from Blake Lively is her showing who she really is. And the truth is, there's a famous quote that says, "When people show you who they are, believe them." And then he talks about some more things that the judge has ruled. He sticks to the facts through all of this. One important question he asks on page 13, I'm going to sneeze again, sorry. Sorry, guys. These allergies. But on page 13, he says, with his career destroyed at the moment, why is he not allowed the right to defend himself and to be able to say that this is not okay? When does it go too far that your constitutional rights are taken away? And when does it go too far that they're taken away in a way that punishes you so severely for trying to defend yourself and saying this is not okay and this defames me? So Justin had filed that counterclaim of defamation. So this is what he's defending at this moment. And then here is the part in question. This is actually Megan speaking in yellow. And she says on page 15, she talks about the CRD complaint, and she says, and then my allegations will be protected, undermining any attempt to sue me for potentially defamatory statements, and then I will leak it to the New York Times so it will get out there, and then everyone will know that I'm the victim here, as opposed to the narrative that existed prior to her filing the complaint, which was she seems like a real, I just say beep, and she is tone deaf on domestic violence, and she seems to have blown up her movie for no apparent reason. Look what she says. Those were the buzz. That was part of the buzz going around about her. She bullies reporters. That was also part of it. So notice Megan herself isn't even the one calling her this name, let alone Brian Friedman. This isn't even Brian Friedman talking. But in this case, even Megan, the one talking, was not calling her this name. She's saying that that's what was being said at the time. That was the take at the time. So here we have another case of Michael Gottlieb just outright lying in another court filing. So this stuff is coming to the judge. The judge sees this stuff. And if he's not watching social media, which chances are he's not, he has no way of knowing that these are lies. Because normally a judge should be able, that even no matter how contentious attorneys get with each other, the things that they file in court should be truthful. A judge should be able to count on these things being truthful. So it's upsetting that time after time, the things that these attorneys are filing are not, in fact, truthful. So they need to be corrected in front of the judge's eyes because, as I said, all he has to go on is what gets filed to him in court or what things might get said at hearings, where we've seen a million times the wayfarers don't really get to speak. And that's the truth. So this conversation goes on. It's kind of long. We're just going to skip out of it for now and jump into the rest of it. Give me a second to find my place. And for people who weren't here from the beginning and just joined, I'm I'm kind of just reading through my script today, and we'll get through and have a little chat afterwards. So I'm not reading comments at the moment, but keep in mind, maybe write down anything that you want to talk about later or any questions that you have as I go through, and we'll consider those at the end. But I want to get through and not keep losing my place and just get the story out. So thank you for not being mad at me for ignoring comments for the moment, just for the moment, but I do want to talk to you after. So here we get to, as I call him, our breakout hero, Kevin Fritz. He's taken over most of the filings. And I think probably the strategy behind that is that Judge Lyman can't even pretend to hide his disdain towards Friedman at this point. So I think Friedman just purposefully took a step back. And even though he's working on things in the background, I'm sure, just as hard as he ever was, I'm sure he'd rather keep his name off of things for the sake of his client, which is a really smart move to do. And so we have Kevin Fritz, who's kind of stepped up, and Ellen's filing a lot of things too. But I love the sarcasm. I love the wit. I love the biting sorts of things that they say in very witty and clever ways that the members of this law team have. So he starts off. So this is in response. Like I said, the Gottlieb letter was strange because normally after a hearing, there are not things filed about the hearing unless the judge asks them during the hearing to file something. So it was kind of strange, but once Gottlieb did, it opened up the door for the Wayfarer party to respond. So he starts off by dismissing these accusations against Friedman. He says it appears that Lively is slowly realizing that there is no retaliatory smear campaign by the Wayfarer parties against her. Consequently, and this is the driving force behind my thumbnail today, Lively is shifting her focus to Liner Friedman, which is the name of the law firm, in connection with her 14th cause of action, which alleges that certain Wayfarer parties, through their attorney Friedman, purportedly defamed her via post-litigation statements to the media. So they're pointing out, we see what you're doing. We see that you've run out of all of these other things. The content creator thing was a bust. So now you're going to change yet again the focus, and the focus is going to fall on Brian Friedman, unfortunately for Brian Friedman. And then we get a little glimpse into Blake's deposition. Now, normally, we don't get to see this stuff because depositions generally stay sealed. They're only used later during the trial to, if someone says something opposite to what they said during their deposition, the depositions can be played back to impeach the person. But since this one's not televised, we won't even be privy to that. So our chances at ever getting a glimpse of Blake's deposition were pretty small. But now we're going to get just the tiniest little glimpse. We also would get a chance if there's an appeal. A lot of times, if there's going to be an appeal, in the appellate filings, there will be not usually the entire transcript, but long sections of the transcripts from depositions. So if that happens, and this case does get appealed by either side, we might get to see in total or close to total then. But for now, this is what we'll get, just these little things that come up in filings. So he says that in her deposition, she admitted that the only ongoing smear campaign about which she has personal knowledge involves, and then we see the redaction. But we do get a little hint afterwards about what that redaction was about, because he says counterclaims filed with retaliatory motive and with a reasonable basis in fact and law, such as the claims filed by the Wayfarer parties against Lively, do not constitute an adverse employment action within the meaning of anti-discrimination statutes. So With that sentence, we learn that most likely what's been redacted here is that what Blake said is the only smear campaign she's aware of is these counterclaims by Justin. So that's really interesting to note. And we can't just say, well, that's Blake. It's just Blake who doesn't know. Maybe her attorneys know. That's silly because her attorneys keep their clients apprised of everything. They're operating on the client's behalf. So it's silly to say that. I've seen that put in on different pro Blake comments on X, that they're saying, well, just because Blake doesn't know doesn't mean her attorneys don't know. Well, her attorneys are working for her. They keep her updated on stuff. So if they know, she knows. So sorry, I'm gonna look at my notes again. Now, we talked about this before, that the Wayfarer party's attorneys, normally, when you file documents that you want the judge to rule on, you're pretty free to cite cases that support that decision. But as we saw, and as we well know, Judge Lyman continuously ruled against them no matter what wonderful case law they cited. Then they started narrowing it down to cases that were just in his circuit, the Southern District of New York. When that didn't work, they started narrowing it down even more, as we see here, cases that Judge Lyman himself ruled on. And even that hasn't worked. But one thing to keep in mind is I've told you before that all through a lawsuit leading up to the trial, all of these little things are being documented for a future appeal. So this material would be good for that, because if they can show that the judge not only ruled against them for almost everything, but even went as far to rule against his own previous rulings, it does start to show something might not be kosher here. So it's really smart for those two reasons. For one, just presenting to the judge his own words, but also if he does rule against himself, it does go pretty well towards an appeal. Now this case, this first quoted case, is Kim versus Lee. This has a lot of similarities because it's an employment case and it has a counterclaim to it as well. Sorry, guys. So we have the order that grants a motion to dismiss because this case was dismissed. And then we also have a decision upholding this ruling from the higher court, the Court of Appeals. So this was also considered to be protected because, like Blake's, where she had filed a CRD complaint and also presumably an EEOC complaint, those make privilege. In this case, it wasn't that sort of case, but it was employment, and so they had filed a complaint through the FLSA, which is the United States Fair Labor Standards Act, and also the NYLL, which is the New York labor law. So those considered this complaint protected. But in the course of a deposition, it was discovered that Kim, who was the employee who was suing, had stolen documents from the employer, Lee, during the time of employment. Now, these documents were taken because Kim claimed that they were taking these to prove the hours that they worked beyond what they were supposed to, basically to prove their case. But either way, there are still rules you have to follow, whether it's for your upcoming lawsuit that you intend to file or your complaint you intend to file. It's still problematic. So when this came out, Lee files a counterclaim, much like Justin filed a counterclaim. Now, the employee tells the court that this counterclaim is retaliation for them bringing this complaint and bringing this lawsuit. So we could easily replace Kim's name with Blake and Lee's name with Justin. And we have a pretty similar situation. So this is what Judge Lyman was faced with. And here's how he ruled. So just to highlight some of his order, he says to sustain a claim of retaliation based on the filing of a lawsuit or a counterclaim, the plaintiff must allege both that the lawsuit or counterclaim was filed with a retaliatory motive and that it was filed without a reasonable basis in fact or law. And he goes on to say only if a counterclaim is baseless can it constitute retaliation under employment law. So these things would all apply just the same as in this case to Justin. So his counterclaim, defamation, would not be considered retaliatory by these same standards. It goes on the next page. Plaintiff's allegations fail to satisfy the test. Plaintiff's allegations with respect to the deposition do not establish a retaliatory motive or that the defendants took action that was objectively baseless. So he's saying there was good cause for the action that Lee took. Goes on to say no reasonable employee should expect that the employer defendant would simply surrender in the face of litigation. So we could say the same about Justin. Should he have just surrendered, or did he have a right to fight back and say, hey, you're defaming me with this claim? Although the threat of a vigorous defense might well cause an employee to think carefully about whether to start litigation at all, that threat is not the retaliation that Congress had in mind in crafting the retaliation provisions of the FLSA. It is simply a function of litigation in which both sides get to present their case before a decision is made. So this was his mindset in this case. That's very, very similar. So it would be wonderful if he sees it the same when it comes to Justin's. And if you haven't already watched, Not Actually Golden, who is on TikTok, but I watch her on YouTube. Not all of her TikTok videos are on YouTube, but I believe the series she's done about retaliation is there. So she's done from way back, and she's done more recent ones where she goes through the legalities of what it requires to bring an actual retaliation claim, what standards have to be met, and it's really, really interesting. So if you haven't watched that, I highly recommend going to see that. Again, that's Not Actually Golden. And she's an attorney. She's super, super smart. And I love her takes on these kinds of things. And this is her field of law. So it's excellent to hear it from her. Now going back to Kevin Fritz's document. So he says, likewise, wait, where am I? No, he doesn't say likewise. So he says counterclaims filed with retaliatory motive and with a reasonable basis in fact and law, such as the claims filed by the Wayfarer parties against Lively, do not constitute an adverse employment action within the meaning of anti-discrimination statutes. Moreover, statements by the Wayfarer parties to the media directly or through their counsel. So he's letting them know, even if the Wayfarer party makes statements to the media, which they haven't, but if they do directly or through their counsel to defend themselves against Lively's bogus claims of harassment, this does not qualify as retaliatory conduct. And I really like that point. And also to add to it that none of the Wayfarer parties have made these statements, but they could. It's within their right, according to Lyman's own rulings. So now we get into a big, juicy, fat lawsuit. McSweeney versus Cohen. And yes, it's Andy Cohen. This is another Hollywoodish case. It's around the Real Housewives. I think the Real Housewives of New York. I haven't watched any of those. Not my sort of show. So I don't know any of these people. Of course I've heard of Andy Cohen, but I didn't know the case personally, so it was quite a read. This is Judge Lyman's order on a motion to dismiss, and very much like the Wayfarer one that was 132 pages, which is kind of crazy. This one is almost that big. It's 100 pages. And again, it's just a ruling on a motion to dismiss. So extremely thorough. The last case was only 30, so I wanted to go through later and see if his normal cases are generally this long or if it's specific to the Hollywood cases. But this is that order, and this is Miss McSweeney claimed that while filming in Thailand, she became dehydrated and lost 7 pounds because, as a Jewish person, she was unable to eat the food because a lot of it contained pork, and that a different type of food wasn't offered. So she claims that she was going hungry. She also made claims against Andy Cohen that he was a threat to her sobriety, and she mentions that there were substances on the set and alcohol on the set, and that this combination of things caused a trigger to her mental health issues. And so that's what this started off as. She filed a complaint with Warner Brothers, who was the production company, with their human resources department. And she received a conclusion letter that said that there were no policy violations. Then she learned that she was not going to be used on the upcoming season. So basically, she was getting fired. And she was angry. So this is when she took it to the EOCC, where she filed a complaint there. She also obtained a right to sue letter, just like Blake did. She filed an NYSDHR, which is the New York State Division of Human Rights. She filed a disability discrimination, harassment, retaliation, and later, not when she initially filed it, but later she adds sex discrimination to this complaint that she files in New York. So she has a state claim and a federal claim. So in the middle of all this, a letter gets sent from Andy Cohen's counsel, so his attorneys, to McSweeney's counsel. And what they say in this letter, and it sounds like it was a strongly worded letter, but it threatens legal action if she didn't retract some of the allegations. So I'm assuming that they're saying these are unfounded, these are not true, these are defamatory, get rid of them, or we're going to countersue you, is what my take of what it sounds like this was about. So she says that Cohen publishes this letter from his attorneys to various media outlets such as Page Six, Deadline, Variety, Hollywood Reporter, and at the same time that the letter gets sent to her counsel, and that he did this to discourage her from this protected activity. So as you can see, there's a lot of similarities between the two cases. Now, it goes on later that defendant's more substantial challenge, and remember, these are Judge Lyman's writings. This is his order about this motion to dismiss. He says the more substantial challenge is to the allegation that Cohen retaliated against plaintiffs in connection with a letter that Cohen's lawyers send to plaintiff's lawyer. But look at what he says, what his take on it is. Courts have held that an employer who's facing a lawsuit filed by its employee charging discrimination can file a counterclaim without committing an adverse action within the meaning of the anti-discrimination statutes, so long as the counterclaim is filed without a retaliatory motive and with a reasonable basis in fact or law. So if he applies this same ruling that he made here to Justin, that would mean the same would be true for Justin, that the courts have held that if this kind of lawsuit, and it's protected, it's the same EOCC that Blake filed in, the same New York State, not the same New York State, Blake filed in California, but it's a federal and a state. And he said, even still, even though those are protected and those are filed, you can defend yourself as long as the motive is not retaliation and it's based in fact or law. He goes on to say even more, noting that it is rare that the filing of a counterclaim can serve as the basis for a retaliation claim. Allowing retaliation counterclaims to proceed in an FLSA action where the court found the counterclaims to be completely baseless and made in bad faith. So while litigation may negatively impact a worker's reputation and dissuade a reasonable worker from making a charge of discrimination, it also enjoys constitutional protection. So this would very much apply to Justin. He says a whole lot. Like I said, it's 100 pages. It's really long, but he makes so many strong points here that if he rules against Justin, it's going to be very, very strange. He says the underlying principle is that the employer should not be required to forfeit a potentially meritorious claim against its employee simply because the employee has brought a claim against the employer. Nothing in Title VII or any other anti-discrimination statute so that includes Blake's, should prevent an employer from bringing a legitimate claim against a current or former employee simply because that employee has complained about what the employee believes to be discriminatory behavior. Indeed, the ability to lawfully prosecute even unsuccessful suits adds legitimacy to the court system as a designated alternative to force. So he's saying not only is this okay, but it adds legitimacy to the court system. Due process requires that there be an opportunity to present every available defense. So this could be taken as Justin's defense. Employers should not be discouraged from expressing their own potential claims, at least where, as here, such claims are addressed to the employee's attorney. No reasonable employee should expect that the employer defendant would simply surrender in the face of litigation. That's an important line, I think, to keep in mind. He's saying Blake shouldn't, if you just change the names of the plaintiff and defendants in the cases, what he's saying in this statement is Blake should not expect that Justin would simply surrender in the face of litigation. Although the threat of a vigorous defense might well cause an employee to think carefully about whether to start litigation at all, the threat is not the retaliation that Congress had in mind in crafting the retaliation provisions of federal anti-discrimination law. So he's saying this is not what Congress had in mind, that the person accused doesn't get to defend themselves vigorously. So these are such excellent points. I'm so glad they found this case. The March letter here did not itself subject plaintiff to any risk of liability. Cohen's lawyer simply asked that plaintiff retract and withdraw her allegations that Cohen had used cocaine and reserved his rights to hold plaintiff's counsel and plaintiff herself accountable to the fullest extent of the law if they did not do so. It also demanded a public retraction and apology. It was sent not by Cohen himself or directly to plaintiffs, but by Cohen's lawyer. So this gets into defending Brian for what he's able to do and say in defense of his client. So going on more about that, the March letter was strongly worded, but it was not objectively baseless. So this is important. The things that Brian Friedman said in that interview that he had every right to be a part of to defend his client, these are the things that he had to be careful of. That it could be strongly worded, but it couldn't be baseless. The letter goes on to state that the allegations lost any arguable legal immunity given that they were asserted maliciously and sent to the media and other third parties with the goal of generating widespread media coverage, painting Mr. Cohen in a false and negative light. So this is what the plaintiff, the one in Blake's position, had tried to do, had tried to send this out there maliciously to the media, as in filing something with, not filing, but submitting a story to the New York Times for it to get widespread and put Justin in a false and negative light. This court has long held that absolute immunity from liability for defamation exists for oral or written statements made by attorneys in connection with the proceeding before a court when such words and writings are material and pertinent to the questions involved. Defendants are entitled to probe those issues as part of their defense. So the things that he said during this interview were fine. Plaintiff does not rest her claim solely on the sending of the March letter to her counsel. She alleges that Cohen simultaneously published the letter to various media outlets such as Page Six, Deadline, Variety, and The Hollywood Reporter. She also asserts that the decision to publish the letter to the media was made with the malicious intent of harming plaintiff's reputation in the entertainment industry, thereby negatively affecting plaintiff's prospective employment or business opportunities. So all of these accusations, they were so mad when that website was made. They were so mad when Brian Friedman made any statements to the media whatsoever. And they're burning mad and now serving a subpoena upon him for this interview that he did with Megyn Kelly. But Judge Lyman's own words, his own ruling in this case, go against that. Plaintiff essentially asserts that regardless whether the March letter had legal merit based on its factual assumptions, the transmission of the March letter to the media was not protected by the First Amendment right of access. And if it was not protected by the First Amendment, that it should be considered adverse. Her claim would have the court find that the March letter was sent to the press not to defend Cohen's reputation, but to deter her and others from making claims of discrimination against Cohen. But plaintiff has not alleged facts in her complaint sufficient to make that claim plausible. When I read through this, it makes me even more shocked that he just completely dismissed Justin's claims with prejudice. How did he go from this stance to completely shutting down Justin's claims of defamation? Do you know what I'm saying? Are you catching that from his decision here in a case so very similar? How did he change so completely? The March letter on its face is not analogous to the negative references or refusals to provide letters of recommendation that the courts have found to be actionable. Plaintiff's allegation also is conclusory and unsupported. The letter casts doubt on plaintiff's allegations and not on plaintiff's performance as an actor or reputation as an employee in the entertainment industry. It further accuses her lawyer, as well as plaintiff herself, of litigation misconduct, claiming that the allegation in the complaint were made with the improper purposes of using them to force an unjustified settlement. The language is the same as the court would expect to see in a court filing accusing counsel of a Rule 11 violation. And while it might have cast plaintiff as a vexatiously litigious liar, it is indiscriminate. So he's saying that the language that was used in this letter that was passed around to multiple forms of media was the same kind of language that you see in court filings. So, if that's the standard, what has Brian Friedman said out there that isn't in his filings? Nothing. In fact, I think he's had a sharper tongue in his filings. And Blake's counsel has definitely had sharper tongues in their own filings. So tellingly, there is no well-pleaded allegation that the sending of the March letter to the media caused plaintiff any incremental harm or injury beyond what she would have already caused to herself by the filing of the lawsuit and the allegations contained within it. Remember that standard too. Plaintiff showed herself to be litigious by filing a lawsuit which she would have known from its targets would receive public attention. And she could reasonably expect that the defendant would deny the allegation. She was not entitled to assume to the contrary. Same with Blake. She filed this knowing it was going to get all kinds of attention, that not everybody would believe her, and that Justin would deny the allegations. So the anti-retaliation provision protects an individual not from all retaliation, but from retaliation that produces an injury or harm. So anything that Justin has said or that Brian Friedman has said, as long as it has not caused injury or harm, the court should not rule against it, according to his own ruling here. All right. He goes on to say that there's a threadbare recitation of elements. In other words, she hasn't proven her case. And so he dismisses it without prejudice. What a different outcome. So coming back to Kevin Fritz's documents, he says statements. Okay, I already read that. But then he talks about New York law providing an absolute privilege for communications made by individuals participating in a public function, such as executive, legislative, judicial, or quasi-judicial proceedings. Now I'm going to skip some of those cases just because this started to get really long, and there's some really good cases, and that one was really, really long, but it had so many good points that apply to this one. So I'm going to move on now to this Brady versus Gaudelli. I don't know if it's Gaudelli or Jaudelli, but whatever it is. This is talking about statements made at all stages of a judicial proceeding and communications among the parties, witnesses, counsel, and the court, provided that the statements may be considered in some way pertinent to the issue in the proceeding. So what this case was, there was a probate case, and in the course of that, statements were made about this Gaudelli. And so what it comes down to in the decision that's made, that an absolute privilege is accorded statements made at all stages of a judicial proceeding in communications. And this is the quote that we saw there. So even though what this attorney said made this guy so angry, and he said, okay, this is defamation, this ruling states that when he spoke about a judicial proceeding, that what he said was under absolute privilege. So if it applies here, shouldn't it apply to Brian Friedman? Then we have the next case. This one, let's see, what was the name of this one? This one is, where are you now? Gottwald versus Siebert, who's actually Keisha, a singer. So this is a producer and a singer, and this is kind of a sad, not an easy one to talk about. So I'm not going to go into the details of the case, but you guys can look it up for yourselves later. But in this decision, it states that the court has long held that absolute immunity from liability for defamation exists for oral and written statements made by attorneys in connection with the proceeding before a court when such words and writings are material and pertinent to the questions involved. The litigation privilege being absolute confers immunity from liability regardless of motive. So a claim was made in this case much worse than Blake's claim, and then defamation was brought into it. But this was the decision about what the attorney said and saying that, no, sorry, this attorney is immune from liability for defamation because these statements were made in connection with the current court proceeding. So these are important legal precedents to keep in mind. And I'm so glad that Michael Gottlieb wrote his silly little letter, because it allowed Kevin to file this one with all of this really, really good information that hopefully Lyman will take into consideration when he makes this ruling. So he goes on to say, Blake is aggressively pursuing discovery for a defamation claim that will surely be dismissed upon a dispositive motion. This is a big statement. A dispositive motion is a request for a court to rule on a legal issue that could potentially end the case or a part of the case, resolving a major claim. So what does that mean? These are things like motions to dismiss, motions for summary judgment, which we've talked about before. Summary judgment is something that's coming up in the future. It's at the end of all discovery when a person will say, Judge, we've seen all of their evidence. There's nothing to this. We're asking you to rule in our favor in a summary judgment motion. So that one would not be included right now because discovery is still ongoing. It could be they're talking about doing this in the future, or they could be talking about a motion to dismiss. Now, isn't all that time passed? No, because in Blake's effort to bring Jed Wallace back into the case after he was dismissed by the court, she filed this second amended complaint. Now, once she filed that second amended complaint, it reopens the ability for Wayfarer to file a motion to dismiss. So this was really a risky move on Blake's side. I mentioned it before all of this, that I was, before she filed one, people were asking, do you think she's going to do it? And I was really torn, because a part of me thought, yeah, she's going to do it because she really wants to keep Jed. But then the other part of me is like, she's going to risk so much if she does do. But she ended up doing it. And so she did take a big risk. So your next question might be, well, why didn't she just amend the portions that have to do with Jed Wallace instead of the whole thing? Well, because it doesn't work like that. If she did just file about Jed, she would be eliminating all of her other claims against everyone else. So if she was going to file this amended complaint, she was going to have to do the whole thing or risk losing it. So we know that before that Justin didn't file a motion to dismiss because he said he wanted his day in court. He wanted to get to prove his case. But this time, now his cases against her were dismissed. And there's all of this other stuff that's happened in the meantime. So he might be rethinking filing a motion to dismiss because he doesn't have to file it on everything. He can pick and choose which parts of it that he wants to file it on. So he could choose to file it on this whole retaliation claim. Because at this point, they've seen her deposition. They've seen that she doesn't really have anything. The only thing she mentioned was his counterclaim, which now, through all of this we've just seen, means nothing. So he could choose at this time to file, and I really hope he does, to file a motion to dismiss on her retaliation claims, which would severely weaken her entire case, I think. So the mention of this dispo, I can't speak today, that they might be considering this is really, really exciting. It could completely change so much about the case. So let me see, I've lost my place. He would still be able to have his day in court for these other causes of action, for the big one that he really wants to defend himself against, but could get rid of all of these others and stop these subpoenas and these motions to compel, these attacks on content creators, these attacks on his attorneys, could all just be poofed away with a granted motion to dismiss. So that's something we can look for as early as this week. So it could put an end to this Costco bulk subpoena that's been causing chaos to all of us. And that would be amazing. It also would leave Blake pretty much with just her SH claims and her other employment claims, which any kind of contract, we still haven't seen what the actual contract was. And we've still wondered all along if she didn't have a good, solid contract, what that was going to do to those other employment claims as well. So we could really see her case start to fall apart from this moment. Now we have one more ruling here we're going to consider, and this is Barbero versus Balasis. And in this case, this is another Judge Lyman ruling, but he ruled that courts have been particularly concerned about the burdens imposed on the adversary process when lawyers themselves are the subject of discovery requests, lest a request to counsel apparently legitimate on its face reflects the intent or has the impact of interfering with or burdening a party's choice of counsel. So now we get into the reasons why this attack on Brian Friedman, according to Judge Lyman's own rulings, is he's ruled against this in the past. He says, noting that courts must guard against the harassing practice of deposing opposing counsel that does nothing for the administration of justice, but rather prolongs and increases the costs of litigation, demeans the profession, and constitutes an abuse of the discovery process. So these are the harsh words that he used in another case when someone was going after opposing counsel. So if he rules differently in this case, it's going to be very, very strange, because this is a pretty strong decision. And he wasn't done yet. He says if the discovery can be obtained from other sources, thus eliminating the need to obtain it from the lawyer herself, and if the discovery is of marginal relevance, the case for permitting it is weakened. The subpoena runs the risk of implicating privileged communications between attorney and client and/or privileged attorney work product, which is what they're saying, including with respect to this very litigation. The party issuing the subpoena must demonstrate that the information sought is relevant and, I can't see, over mine it says slide 33. The allegations and claims at issue, and basically that's the strong point. So we've gotten a really good look, and bravo to Kevin Fritz and the Wayfarer team for putting all of these cases, Judge Lyman's own cases and his own rulings, to show what his standing has historically been on these situations. And we'll really get a look at whether or not he adjusts his thinking on Blake's behalf, because that's the only difference here between these cases and Blake's case, is that it's for Blake and not for these other people. So, moving on here. Because the subpoena risked implication of privileged attorney work product, the documents sought were of marginal relevance, and plaintiff failed to demonstrate the information sought could not be obtained from another source. So that's his reasoning behind citing this case in his point. So that brings Kevin's letter to an end, and now we just got to wait to see how the judge rules on it. But overall, it feels like things in this case are starting to shift. But the rulings on this matter are really going to let us know whether or not that's true. So as it stands right now, he has to rule on this motion to quash that they had the hearing for and what these two letters were about. We've also, as content creators, as I mentioned before, people questioned, why file, you were out of it. Why would you file a protective order and sanctions and bring yourself back into it? Well, I'll tell you why. Because if you read the wording in Ezra's letter where she withdrew the subpoenas, it was full of lies, and I covered that previously. Not only that, she says things like, at this time. When Leanne directly asked her in an email, her answer was very similar. Nothing about what she said gave us any sort of confidence that this withdrawal was for all time and not just a temporary withdrawal. The other situation, and I said this in the last live too, was that Andy of Popcorn's Planet received more than one subpoena. He got it for different platforms, and then there was a third one from TikTok and a copycat account that we think they thought was actually Andy. So if she was filing, and there's, like I said, over 60 unaccounted for subpoenas out there. So we wanted assurance from the court that we were withdrawn, and we were withdrawn for good. And that's the purpose of the protective order that we asked the court for. We also asked for sanctions because it was just ridiculous. Sanctions as a punishment. And the other point of the protective order was to protect other people who maybe didn't get notification, because our point about the subpoena was not just that it was wrongly served on us, but that the subpoena itself failed for so many legal reasons. So we were asking the judge to rule that this subpoena itself is no good. And it was really interesting to me that mine, although I filed it on Monday, it didn't get posted until 5 p.m. on the 31st, which was the last day for people to reply to Google and keep their information safe. We had to have a court-stamped motion to quash turned in to Google by that day. At least mine. The later ones had later deadlines, but that was the Google deadline. And I just thought it was strange that it didn't show up with all of those case laws cited for why this subpoena was bad and should be pulled from everyone. So that means that the Google subpoena, anyone who didn't make that deadline, their information became available to Ezra. Or if Google stepped up and continued the fight, we don't know what happened with it after that point, because all the people I know got our motions to quash put in. But for all the people who didn't, who knows? Who knows what happened? their stuff could already be being accessed. And it makes me sick. It makes me sick to think that some people never received their email because it went to spam, or because the email that they signed up years ago for their account was long lost. They stopped using it, so it got deleted. Who knows? But it was just a sickening thought, and we wanted the court's assurance that not only were we safe, but everyone else was safe. And he posted them to the docket, but he never gave any instruction on them whatsoever. He didn't rule on them himself. He didn't ask either party to give their comment. It was like our motions to quash. When he accepted them onto the docket, he gave deadlines to Ezra to reply. But for these, not a word. They're just sitting there on the docket like they don't exist. And that kind of makes me mad, because this is his job to oversee the things that come out of his court. And the way she obtained these subpoenas, or I always say these because it should be multiple, but it's not, it's one. The way she obtained the subpoena was not correct. That's his responsibility to fix. And because he didn't, all of these people who didn't get their responses in by the deadline are at risk. And it literally makes me feel sick. And we saw the big list that went to Google and X and TikTok. We never saw I couldn't believe when they said the number was 107, because what are those? What do those go to? We don't know. And there may be a lot of people who got them and they don't know. So to me, it's so wrong that the judge didn't even address those. But we did everything we could do. It's literally in his court to decide now. But if he ignores it and somebody comes later whose rights were violated, he'll have to deal with the consequences of that. But the big news to look for is whether or not whether or not Wayfair files a motion to dismiss, and what the judge rules on this motion to quash aimed at Brian Friedman and the law firm. So I'm going to go through. We'll start with these. Just Ricardo, hello lovelies, wishing Legos and stubbed toes on Blake Lively and Ryan, and Ezra, and Michael Gottlieb. Justin Smotherman, thank you so much. The fact that the entire world isn't pointing out the clown car show that it's Lively's defense in every headline makes me give up on the world, really. But thanks to our darling Lauren Knighty, she did break through into mainstream media, so hopefully it will open things up for more people to talk about it and for them to talk about more of the details. And maybe, just maybe, we're headed for a change. Nicola, thank you so much. I hope Friedman is accumulating all the false slander against him and brings a case against Lively and lawyers after Justin's case. I do too. I hope there's a lot of things happening behind the scenes that we haven't seen. We still haven't seen anything brought to the court about Van Zandt. And I see people comment, why hasn't Judge Lyman addressed it? He really can't. He can't do anything until it's brought to him. So I'm assuming that there's still a gathering of information about that, and still them trying to decide if this is something they're going to bring to this court case or deal with after this court case in another court. We don't know what's going to happen with that. So you guys, If you saved anything you wanted to ask about or any comments you wanted to make, I'm opening all of those up now for a little bit. I'm going to pause to get a drink. Yes, Wes, I agree. Abuse of process. Ryan's money. Yeah, he's spending a great deal of money on this, but I think he's behind. I've never really talked about all of my conspiracy theories of where I think this all came from in the first place and how Ryan played a part in that. I have seen a lot of other people who have the same opinion about that as I do, and I think a lot of you do as well. But I think Ryan has to keep paying because, just my opinion, I think he's behind so much of this. I wonder who his clerk, because that may be part of the problem here with things getting on the docket. Diane, that's very, very true. Because they determine a lot, actually, what gets put before the judge's eyes. They even write a lot of the responses. So if they do a lot of the research, even if they don't actually write the response, they get a lot of the research and pass it on to the judge. So if the judge is not doing their own research, if they're relying on research brought to them by clerks, a clerk can shape the opinion of a judge. It's a fact. I don't know at this point. I don't think at this point sorry, I'm supposed to read these out loud. FNAS, can Brian Friedman sue the lawyers of Blake Lively for defamation? Yeah, my honest answer is I don't know. I think they have a lot more information available to them than we have. But from what we've seen, I don't think so. But I don't know. Nat says these public media outlets don't represent the world to me. They represent the elite who pay for PR. I don't read any of the garbage. I have to say, I've said it before. I am generally not into conspiracy theories, and going into this case, I really gave mainstream media more credit than they deserve, come to find out. Because I always assumed from different movies or books you read about these diligent reporters that just at all costs they want to get the real story out and pride themselves in getting to the bottom of the real story. So I kind of had this idealized version of what they were doing, and it's been shattered by this case. Because when I see these filings are there and we're all talking about it and the media just ignoring it or giving these crazy spins on it, I will never believe mainstream media again after seeing this case. That's what this case has done. Of the many things it's done, it's completely made me lose all faith. It's Q&A time, crew. Yes. Thank you, Khaleesi. Van Zandt must be investigated. Absolutely. I'm working in the background. In fact, that's what I was working on before these documents came out. I want to make a little documentary style, not do it live, but do like a prepared, just a short, concise story telling of this Van Zandt. Because back when Van Zandt happened, when it was first discovered, and Without a Crystal Ball covered a lot of that at the time, we've gotten so many new people to the community since then that probably don't know about it or know very little about it. So I was thinking it's about time, especially with mainstream media opening up some of this stuff. It's time to get this out there and talk about it constantly. So cute. Ryan Reynolds, Suzette Rodriguez says Ryan Reynolds is behind all of this. He doesn't let it go. I agree, Suzette. I agree. Please see Lena's comment. Is it up a while back? Did I not go back far enough? I don't see it. Lena, can you type it again? I'm sorry to ask you this. Oh, thank you. Okay, I'll go look at that real quick. This is all just crazy. Yes, just the mess. It is. Christina. Diane, okay, I already highlighted that one. That's right. How did I went backwards somehow. Yeah, I did. I went backwards. Jackie says, I think there should be better checks and balances in the courts for when attorneys pull these unethical Van Zandt and blanket subpoenas and judges won't put an end to it. I agree that the power that federal judges have that's another thing that really shocked me that I learned with this case. That all judges have an immense amount of power, but federal judges is really, really high. And there aren't a lot of checks and balances in place when they make mistakes. Even filing an appeal only has like a 20% chance of happening. And then there's the extraordinary measures. The extraordinary things like filing writs with the higher courts. Those are even lower. I think the highest a success rate they have of even getting looked at is like 10%. It really, really leaves a judge completely on their own for their rulings to stand with no one really checking on it. And I have to say, I don't like that. She's made him toxic trying to cover for her. Lisa says, Ryan is behind this for sure. Circus Faye says, Cassidy, do you think it's possible that the reason Lyman is extremely deferential to Blake Lively in his rulings is because he's trying to preclude her from being able to make a case for appeal when she loses? You know, after I read his things today, I really started to wonder about that. I did. It almost, I'm going to say almost, and I'm going to tell you why almost made me feel like maybe I have been too hard on him, because maybe that's what he's doing, is securing the future ruling so that nobody can say she wasn't given complete opportunity to plead her case. That did really cross my mind as I was reading, because I have to say, those orders that I read, and I read a lot of them to you today, he did a good job. And I feel like his rulings were very fair and very, very legally sound. So I did get that feeling, but then what made me change it to almost is the way he treats Wayfair. He treats them with, it looks like disdain. He cuts them off. He doesn't let them finish. He's downright rude to them. So I don't know. I don't really know what the motivation is, but it would be amazing. And I'll send him a fruit basket if it turns out that that's what it was. Ryan Reynolds and Blake Lively seem like quite the couple. They complete each other in psychosis. I'm not going to disagree with that. Ryan doesn't care if he destroys her, says Jane. I agree. And like I said, I'm did you hear that pop? That was my knee. My knee that I had surgery on. It's been doing that. I think I need to go have it looked at. But the full-on recovery time to get to like sports level was like 9 months, which really shocked me. And maybe I've done too much. But it's been like that loud pop, that was my knee because I straightened it. But back to Ryan doesn't care if he destroys her. This is one of my, okay, just absolute opinion and far-flung out there ideas. I've seen other people say it too, so I don't feel embarrassed to say it here. But I think this movie, I think everybody involved knew that it was gonna be a big deal. There was so much hype leading up to it because of all the hype with the book. In spite of the criticism against Blake that would have died down and did die down until this complaint was filed in the New York Times article. In spite of all of that, it made a ton of money. And by every indication, Blake wanted very much to own the sequel, which would have brought even more. And I think personally, you've heard that Ryan's controlling. You've seen the way he was about Scarlett's fame, the way he kind of ended Blake's career just as it started to take off. A part of me wondered if that's not why he's so into this, why he's willing to do all of this. Does he just want to make absolute positive her career is dead forever and can't be resurrected like Deadpool can? I have to wonder that. Jess the Mess says, I feel Ryan Reynolds didn't like what he saw in the editing room. That's another thing. That's another thing. I think so too. And I think the messages that he saw and the way she kept having Ryan over to their home while he was away filming, holding their babies and working till late into the night. I think he felt threatened. I mean, this is all just personal opinion. So don't subpoena me again, Deadpool. Alleged, yes. McPeewee says, the clerk is terrible. The judge has ordered things sealed twice that are still up. People's addresses. Yeah. See, I honestly don't know whose responsibility that is. I would think that whatever attorney filed something without properly redacting it needs to be the one to fix it, but it might be the clerk's job. I don't know, but yes, the stuff is still up. Roses Wild says, I think the filings for Stephanie Jones and Blake Lively to only have to produce from one party was because there was shady stuff like Van Zandt, so they won't have to turn over copies from other camp to find discrepancies. That could be because they made it clear they wanted it from each party for the reason of comparison. They blatantly said it in the filing, and then it's like, oh no, they can share. So that kind of stinks. And it's stuff like that that makes me not think the motive behind the judge is that. Gigi says, yes, Blake is spoiled, but Ryan is vindictive. Yes. Yes. Jane, I've been worried about the clerk. Khaleesi says, just an opinion. Please don't sue us. Exactly. Hayden says, Cassidy, will Blake's lawyers ever get in trouble for blatantly lying repeatedly to the court? It's really hard to get any kind of discipline. They should, but it truly depends on Judge Lyman. He's the only one that can do it. You would think that a judge would get mad at being lied to, though. I don't know. I wish they would. I tried my best to bring it to his attention, but my motion to quash got dismissed without him probably reading it, and this one's just sitting there unread. So at least Kevin Fritz is doing it now. Francesca says, in my opinion, Ryan Reynolds is behind over 90% of this mess and the only one with the money to pay for all of this. It's costing a fortune. Agreed. Yeah, Blake doesn't have this kind of money. RS says, no, he was already like that. She just pointed him in Justin Baldoni's direction. Agreed. Ryan was already like that. Dahlia says, my only question regarding the bulk subpoenas as a matter of law is that technically they were served on one entity, naming all the info they wanted. Not sure if any case law on it. So That's a really good question. So here's the thing. There are in certain situations, but it's very, very limited. There are cases where one subpoena can serve on multiple people. But this situation, it wasn't just served on Google. My same subpoena was the same one sent to everyone. It was also served on X. It was also served on TikTok. And we don't know where else it went to after that, the traveling subpoena. Each of those things were in a different jurisdiction. Each of them had different things that they asked. So like what was asked of me in Google was different than what Leanne was asked on X. They had different deadlines. There were too many different things. So there have been cases where one subpoena was sent to Google. In fact, I think is the case that I'm thinking of. It was a case of copyright infringement. So it was served exclusively to Google because it was it YouTube? I can't remember, but it was served on one entity only. And it was for copyright infringement, which is illegal. You can't do that. So these people's action, there was no question what they were doing was wrong. And not only was it allowed, but a new law was made specifically for copyright infringement subpoenas like this. So they have their own section of law now. They don't have to go through all of this other stuff that subpoenas like what I get was served or what Google was served for me. They don't have to go through all that. They have their own exceptions and specifications, so they don't have to do that because copyright infringement is illegal. There's no question. So when it comes to things like that, yes, it's possible. So if they go through and find a bunch of people all in one whack, yes, they can serve one subpoena that goes to all of those people or that goes to Google for all of those people. But in this situation where you have so many big differences in them, it's not the same criteria because it wasn't just served on Google. It was served on multiple. We only know of 3, but if there's 107, it could possibly be Reddit. It could be Discord. It could be, somebody joked about it being MySpace. It could be, yeah, who knows? I don't know all of them. I'm not so cool. I only do the basic ones. I just finally made a TikTok just to secure my my name on there because it's recommended for your brand that you do that. So after I heard about Andy having a copycat, I secured. I haven't used it for anything. It just exists. I think. I hope I did it right. But yeah, so there are some. It happens, but it has a lot of regulations to it. Elsrich made a comment. This is Ashley. Elsrich made a comment in a recent video that the clerk must have bought to end up on Lyman's docket. I wonder. Anything else Rich says, I believe it. That's all I can say. Joy says Ryan Reynolds is a malignant narcissist like Blake. Did he cause the almost fire and kidnapping threat to Steve Sarowitz? I don't know. Every time I say no, then something turns out to be true. So I never say no anymore. I just say could be. Wes Short said if he doesn't respond to his wife, she will make his life miserable. I think he probably makes her life miserable right back. Just my opinion. Critic Cafe, it's so obvious the Friedman accusations are a cover. In my opinion, Gottlieb wants his phone data to see who's talking from It Ends With Us and the Swift source. Yes, I could definitely see that. They panicked so badly about that investigation. That was a wild overreaction. And the Taylor Swift subpoena as well. So yeah, that could be. And they lost access once Jennifer Abel figured out they were still accessing her phone come January. Ryan Reynolds is a firebug. Judge Lyman created this mess, says Chatterbug. That's true. Christy says, do clerks redact or are the attorneys supposed to prior to submitting motions? The attorneys are supposed to. I'm Not a Bot says, wonder if anything else about Taylor blackmail will ever come out. Me too. I want to know. Come on, Tay-Tay. Tell us. Jane says he can bring them up to the bar. Lizzie says, half of you liked the stream. Wes says, money is certainly talking. Let's see. You don't need to pay anything to send. You don't need to pay anything to send a press release. I think Blake and her mother started smearing Justin and Ryan. Thought he would come in to save the day. Says Choctaw Nation. Nat says, yep, I think that's why Ryan came to Blake's deposition. Like, she better not screw this up. I think everybody knew she was gonna. Rose is wild. Me too. Now I don't trust any mainstream media since this case. Exactly. Guys, I'm gonna have to wrap this up. Oh, we're almost done. I can get through the rest of these. McPeewee says Ryan Reynolds did admit to burning down a school. Little Raisin Eyes artist. Whoever started Raisin Eyes is so hilarious. Just Snooping says, can Friedman subpoena Blake and Ryan for any communication between them and Lyman since Blake is chasing everyone? Lyman lets her. I don't know what they're going to do from this. Let's see. Lots of sames. Diane says, this case has opened a lot of people's eyes about mainstream media. I'm Not a Bot says, Megan Toohey ruined her stellar reputation, showed herself so biased. Oh, absolutely. I would never read anything she writes ever again. That it has, Diane says Christina. Chatterbug says, really changed my perception of reality. In fact, yes. Yo says P says mine was shattered a long time ago. Rose is wild. It's done that to most of us. Francesca, certainly. Ryan Reynolds was at the deposition, likely coaching Blake during the breaks, in my opinion. Probably giving her the evil raisin eyes if she got anything wrong. Jane says they don't pay. However, they say, run this. I'll get you an exclusive. This is true. That's what it comes down to. Beady eyes and high forehead. So handsome. Yuck. IME represents 2/3 of Hollywood. They are not talking, says Wes Short. Miss Jessica says, dang it, another movie I loved ruined. Francesca says, I agree. I knew mainstream media was deteriorating because it was all brought up by large corporations, but it's worse than I thought. Oh, yeah. Go check your inbox. I know. It's been eye-opening. There's so many. I don't want to. Yes, the law firm can be sued. Trump sued this law firm and won. You would think the motions, Christy says, you'd think the motions have to be in full to the ledge so he can read, but when published, it should be redacted. So possibly clerk related. I think they're supposed to supply both. Let's see, brought up. Love your documentaries. Thank you. You don't stand for me, Blake Lively. A Hayden says, Blake has really opened people's eyes to much corruption. I've become so disillusioned with everything. Yeah, I'm Team Truth and Team Justin, said Brittenham. Eliza Little says Van Zam should be talked about more than the stupid fake smear campaign. It should be. It should be. And I think that's one of the reasons that the subpoena thing was such a big deal to stop us. Because a lot of us who were subpoenaed, we talked a lot about Van Zan. Jane says mainstream media is a propaganda machine. I believe it. The timing's odd. These subpoenas went out when everyone was talking about Van Zan. Oh, yeah, I just said that, Francesca. We agree. McPeewee, luckily Ryan wasn't allowed into the deposition. You know he was fuming and pacing for 7 straight hours. You know it. I didn't know he wasn't allowed in. I remember that they said he wasn't going to be, but then they said he came, so I thought, oh, he got to go in. Felicia says, coming from the newspaper business, I'm shattered by how mainstream media has handled this. Journalists used to be the watchdogs of society. Exactly. That's what I was saying earlier. Jess the Mess says, if this goes to trial and Blake loses, is there a chance she can be sued or in trouble for filing false allegations? I'm a ding-dong and confused. You're not a ding-dong. That's a really good question that I don't have the answer to either. I think it depends on what all evidence is uncovered, what things were said in depositions, not just hers, but like what other people have to say, what kinds of things were uncovered in her text messages to other people. There could be some plotting that we don't know about, that we think happened, but we don't have proof of happening. So I don't think we know at this point, but if there's evidence of it out, that's something I would absolutely love to see. And thank you, Jess the Mess, for the super chat. Okay, guys, I'm going to call it quits for the night. Sorry for all the comments I didn't get to. And for the ones, you know what I'll do? I'll take the ones that you sent to me. You don't stand for me, Blake Lively. I will take those and make a post or add them to my next video and try to answer those, because I know you would have selected really good ones that you wanted answered. So, and I don't want your hard work to go to waste. It's the middle of the night for her, guys, and here she is modding for us. Fruit basket. Yeah, Lar. That's what I said. Okay, so yeah, we will call that a night. Enjoy the rest of your weekend. Thank you so much for taking time out of your Sunday to spend here with me, and for being such a delightful little community. And thank you, mods, very much. I'm not used to having to have you there. I hope we didn't get any trolls today. I know the last couple of lives we did, and so we had to make that happen. Yes, Gail, I will answer this one last one. After the discovery, doesn't the judge get to decide if there's enough evidence to go to trial? So it's not just something he decides, but they file what's called motions for summary judgment. If they feel that the other side has not made a good case, they can, or that their case is strong enough, they can ask the judge to rule in their favor. And that's what that is at the end of discovery. So have a good night, everyone. Hope to see you all here next time.